All right, I gotcha.
Where are the notes? Where do I see the notes?
Right here.
Okay, right there. Okay, thanks. All right, well, welcome everyone. I'm Kim Browning of Blue Chip Estate Planning, and thank you for joining our first session in our educational series, The Dirty Dozen Estate Planning Mistakes. Estate planning is often one of the most important yet most misunderstood steps in securing your family's future. Too often we think of it as something we'll get around to later, or we assume that a quick online form or a simple conversation is enough to protect what we've spent a lifetime building. But the truth is, mistakes in estate planning can be costly, not just in dollars, but in stress, time, and in unintended consequences for the people that you care about most. Over this series, we'll be walking through the Dirty Dozen, the 12 most common and most damaging mistakes that we see individuals and family make when it comes to estate planning. From outdated documents and do-it-yourself disasters to hidden traps, family feuds, and the overlooked risks of disability and guardianship. We'll cover the real-life missteps that can derail even the best intentions. Each session will unpack key issues, explain why they matter, and offer practical solutions to help you avoid the pitfalls. Whether you're still contemplating your first estate plan, updating an old one, or just trying to understand what all the documents mean, this series is for you. So let's get started with the Dirty Dozen, mistake number 1, pay me now or pay me later. Now we love questions, so please use the taskbar in this webinar to write any questions that you might have. Being penny wise and pound foolish, thinking that you can do it all yourself, and you end up in litigation instead. This is a familiar phrase, but in its context, it's more than just saying it's a warning. Far too often, people try to save a few dollars to do it yourself, doing do-it-yourself legal forms, only to leave their families with massive legal bills, fractured relationships, and months or years of unnecessary court involvement. In this segment, we're going to be touching upon the most common and most costly mistakes people make with do-it-yourself planning. We're going to touch upon real examples of Michigan families who have paid the price, and what Michigan law actually requires and why generic templates often fail. We're going to also provide you with simple, affordable steps to protect your loved ones and your legacy. And at that end, again, I am hoping that you will all be very generous with your questions, so don't be shy. And in fact, why don't we just start with one? Have any of you ever witnessed a family dispute over a will or an inheritance? You can just type in the chat, yes or no, no details needed. It's more common than you think, and this might get you going with the questions. Thank you. All right. So let me just start by giving you a scenario, painting the picture that your family has just lost you and they're grieving and overwhelmed. Then someone says, well, at least mom left a will. They then open the envelope to find that the document is not a legally valid will. Why? Because mom downloaded it from the internet, signed it at the kitchen table, and never had it properly witnessed. Now your estate is headed straight to the probate court. Your children are hiring lawyers, and what should have been a peaceful process becomes months or years of costly conflict. This is the trap of do-it-yourself estate planning. and you think you're saving money, but actually you're passing the cost and stress onto your loved ones. Michigan law is specific, it's strict, and it's not forgiving of shortcuts. So here we're going to start with the common Michigan do-it-yourself estate planning mistakes. A, improperly witnessed wills. Michigan requires 2 competent witnesses to a will. Now, the will must be signed in the presence of 2 competent witnesses at the same time. And using a template, signing it alone at your kitchen table won't work. So let's take another example. We have Sandra from Grand Rapids. She used a free online form. She signed it alone and later had 2 friends sign their signatures separately. And when she passed away, the probate court threw out the will. Her children spent over a year and $15,000 in legal fees trying to sort it out. Now, a common question is, well, what if I don't have 2 people that I can go to? Can I use my spouse? Can I use my children as witnesses? While they're not strictly forbidden in Michigan for you to use someone who is going to stand to benefit from the will, it's really not good practice. You should try to find witnesses who are not interested, that they're people who aren't going to actually inherit. Another mistake is not revoking previous wills. If you don't clearly revoke your old will by destroying it, then a new will that you prepare might also be litigated. Michigan courts try to resolve the contradictions, and what the second will do is the court will look to both wills, they'll compare them, and the second will that has a term that is exactly the same in the prior will continue. But if you try to transfer, say you're going to go ahead and give your cottage property to daughter number 1, and then in your second will you say that it's going to go to, daughter number 2, you could end up in litigation because someone is going to end up stating that that was a mistake. There was an omission, or it's going to open the door to this litigation. Here's an example. Tom created a second will using an online form in Traverse City. He didn't mention his previous will, and he didn't destroy the old one. His family battled over which will was valid, burning $30,000 in legal fees and nearly 2 years in probate. In this particular case, what he didn't do is the original will was valid. It identified who a personal representative. It nominated 3 different people as personal representative. It specifically named assets to be distributed to his beneficiaries. But then when he tried doing his second will on his own, it didn't say, I revoke all prior wills, and it didn't even identify who he wanted nominated as a personal representative. So his first will, he was married, and it named his spouse to be the personal representative. So when he hand drafted the second will, because it didn't revoke that nomination, his ex-wife, who was the mother of his minor children, became the executor of the will, and his older children of another marriage, who he wanted to be able to administer the will, ended up taking to court, and they spent literally thousands of dollars in deciding who was going to be personal representative, because everyone wanted to be in charge of his multi-million-dollar estate. So a quick check on the audience. Anyone out there have more than one version of a will saved somewhere? Oftentimes, you share your estate plan with whoever you are nominating to be your personal representative, letting them know that they are appointed and keeping it safe in the event that you pass away. And then you could forget to bring it back and ask for it back when you update your estate plan. Okay, well, if you do, try not to share your estate plans out with anyone other than your estate planning attorney, or please make sure you pull those back if you do update. There's another common misconception about preparing your estate plan and confusion about notarization. Some people just think that you can notarize your will and that will be sufficient. Although we do in Michigan do notaries because we will allow for a self-proving will. A self-proving will under MCL 700-2504 requires a notary, but it also has the witnessing requirement. And the purpose of having the self-proving will is so that you don't have to actually call the witnesses to court in the event that your will is contested. So to this point, I had a will contest where we had to present it in court, and the problem was it was actually a holographic will, and the gentleman had his neighbors witness the execution of this will, and then it was contested by the kids. We brought it into court, and the witnesses, both of them had passed away. So there was actually no one to attest to that this being a valid will. And it wasn't it wasn't notarized, so it wasn't a self-proving will. So we needed the witnesses to appear in court. So it caused a lot of delays and a rejection of the will inadvertently, even though everything else was done correctly. So now we're on holographic wills. A holographic will is a handwritten will, and the actual legal requirements for a holographic will are different than a typed will. Michigan requires that the dispositive provisions must be in the testator's handwriting. So many times someone might type up a will and then sign it and without witnesses and say, well, this is my holographic will. Well, that's not going to pass the test, because the dispositive provisions, meaning I, Kimberly Browning, want my 3 children to take my cottage property equally. Those are the dispositive provisions. It's transferring of my assets, specifically who I want to receive what assets must be in my handwriting. Also, the document must be dated and signed. And this is something that we saw in Michigan. We saw holographic wills being litigated in the Aretha Franklin litigation. She had different pieces of note paper that described what she wanted done. Not all of the documents were dated. They might have been signed, but they have to meet all of these requirements in order for them to be considered a valid holographic will. The other requirement is they must show clear intent to be a will, because oftentimes people will write down their notes. They might just get out a piece of paper at night and think that they want to redo their will, and they can prepare notes. I want this particular asset of mine to go to this person. I want this asset to go to this person. Well, that technically isn't a will. It's notes that you might end up bringing to an estate planning attorney. So it wasn't intended to be your will. It's specifically just notes. And the holographic will, it doesn't need to be witnessed, but it does need to be signed and dated, and the dispositive provisions in your handwriting. Here's another example. After his diagnosis, Bill from Kalamazoo scribbled the will on his notebook paper, leaving everything to his girlfriend. No one witnessed it, but it was signed, not dated. And after his death, actually in this particular case, it wasn't just his estranged adult children, but his estranged wife challenged it, arguing that it wasn't a real will. The court eventually upheld it, but not before a year of litigation and $25,000 in legal costs paid from the estate. Now, in this particular case, this was another COVID case. Bill was getting a divorce. He was living in his cottage property and he hand wrote a will. He ended up passing away, and he had a will that was drafted by an attorney. It was registered with the Oakland County Probate Court. So the estranged wife was aware of that, went to the Oakland County Probate Court registrar, pulled his last will and testament, submitted it to the probate court to start the probate process. And then as the kids were cleaning out the cottage property, they did find the holographic will. And lo and behold, girlfriend steps forward trying to take everything away from the family. And this ended up in litigation for several years. And not only did it cost $25,000 in legal fees from the estate itself, not all legal fees are paid out of the estate. The estate only pays for the personal representative fees. So if someone is contesting the will and they're not the actual personal representative, he or she has the burden of paying their own attorneys. So the litigation fees that are demonstrated in this PowerPoint presentation are specifically to the estate, and they run a lot higher if you look at each case as a whole. Another common Michigan do-it-yourself estate planning mistake is appointing ineligible trustees or executors. So in this case, you have to really take your time to think about who you want to appoint. And sometimes this is one of the reasons that cause people to stall in the process. So it is an important position, but you got to make sure that you don't end up making these small little mistakes can actually cause huge repercussions. So if you pick a non-resident serving as the executor, well, yes, trusts are portable documents, meaning that they can be administered in several different states. But if you have a will and if you appoint a personal representative to serve, it can certainly delay things because you need to have someone available to go to court. Not all counties will allow the fiduciary to participate all hearings via Zoom. Also, banks may refuse to work with non-local trustees. This has been a situation where the statute actually says for a trust that the trust situs, which means where the trust is going to be administered, is where the trustee resides if the trust itself is silent on that point. So the actual trust administration might end up changing out of the state of Michigan into a different state, and that could trigger all kinds of problems. Another one is foreign trustees. Sometimes people, they might nominate a child who's currently in Michigan, but they end up moving abroad for work or other reasons, and having a trust administered by a trustee out of this United States can cause some very serious tax implications. So you want to be careful who you're choosing to be your administrator of your estate. Now, to the audience, if something happened tomorrow, do you know who would manage your estate? Please think about that carefully, and Hopefully a lot of you have this taken care of, but this is one of the first steps that you need to think about when you're preparing your estate plan. Executors or trustees with personal issues, substance abuse, bad finance, family conflicts often derail the estate plan. The real consequences when you appoint people who are the wrong people, what happens really is the estate does not get administered. And some examples are you have the personal representative living with the person who had passed away because they were caregiver, and they don't actually want to administer the estate because they're living in the house. And if they administered the estate, that would mean they'd have to move, they'd have to sell the real estate, and it causes problems. Or maybe the personal representative isn't the person who's living in the home, but maybe it is their brother or sister who's hit hard times and they've been residing in the property and they don't want to actually go through the eviction process. So sometimes years can pass by without an estate actually being administered because you've chosen the wrong people, and things can sit for a long time. It can be delayed. So let's go over the numbers. Do-it-yourself estate planning may feel like it's free, but it's not. It's just deferred costs. And here's what families often pay when things go wrong. Here we go with the invalid will challenge. Again, these are numbers that the estate pays out. So this is less money to the beneficiaries. However, the beneficiaries are the people contesting the issue. They pay out of pocket. So these numbers are actually higher. The extended probate process can be delayed anywhere from 6 to 24 months. So here we're talking about not only the cost that is coming out of your pocket, but the cost of time, stress on the family, 6 to 24 months. Intra-family litigation, many times it's 30,000 plus. You can end up with many, many hearings, mediation, back in court, trial. Trial's a minimum of $30,000. And then IRS penalties. Again, having a foreign trustee, it can cost you in tax dollars. And then fixing do-it-yourself documents. Even if you thought you did everything right, you have to go back and you have to fix things that's out of pocket. All right, Michigan legal formalities that matter. Michigan law, as we discussed, is not flexible when it comes to estate planning. The Estate and Protected Individual Code, often referred to as EPIC, spells out exactly what's required for your documents to be valid. So as we went over, a valid will must be signed in front of two competent witnesses who are present at the same time. If it's a holographic will, it must be in your handwriting, signed, dated, and clearly intended to serve as your will. Any revocation must be clear by physical destruction or the statement by a new will stating I revoke all prior wills and codicils. Choose your executor very carefully. And then what we haven't really talked about are the specific provisions for other documents, including powers of attorney, which need to be notarized. They should also be witnessed. Living wills, which are referred to now as advanced directives dealing with end-of-life decisions. Those documents do not need to be notarized, but the execution, including the witnesses of those documents, are very, very specific. You cannot have anyone who's related to you. You cannot have the person who you're nominating as your patient advocate. You cannot have caregivers. And then we have HIPAA authorizations. So when do-it-yourself is especially dangerous, let's talk about situations that you really need to be careful of with do-it-yourself. And I highly recommend you speaking with an attorney if you have minor or special needs children. Now, if you download a do-it-yourself form and you name a guardian for your minor children, but the form turns out not to be valid because it's improperly witnessed, now if it is challenged in court, you're going to have a judge decide who's raising your children and not who you've specifically nominated. With special needs children, you certainly can prepare a special needs trust. Now, again, this is something that you definitely need an attorney to draft because the rules for establishing a special needs trust are very, very specific. And I do recommend that you do establish a special needs trust for your child as opposed to the other route that people choose, and that's completely disinheriting your special needs child to let one of the other children or another family member hold the money and do the right thing and distribute to the special needs child as needed. And the reason why people don't give outright to special needs children is because these governmental benefits that the individual will receive through Medicaid or SSI are asset specific, and receiving an inheritance could disrupt their benefits. Okay, second marriages. When you're dealing with second marriages or blended families, all sorts of issues can arise. In these situations, assume your spouse and your children from your first marriage will work it out. They'll figure it out. Well, that's the worst thing to do. Another thing is if you leave everything to your new spouse and you put it into a trust and you allow the trust to be amended, revoked, even after the first of you dies, then they can update the entire plan and leave everything to their own biological children, completely cutting out your kids from your first marriage. So there's a lot of unintended things that just never even arise in, when I sit down with my clients and I have to go over all these scenarios, I can tell you almost every single time I hear from my clients, oh, I never thought of that. Well, most people don't, because I think most people think the best and they think the best of their family, and they don't ever anticipate that things could go as sideways as sometimes they do. Real estate in multiple states. Many Michiganders have property also in Florida. And if you don't establish a trust, or if you don't establish a deed transferring ownership, you could end up with a probate estate that is in both states, not just one. So a properly structured revocable living trust can avoid multiple probates and make distributions seamless. Another very important time to reach out to an attorney is if you have business interests. Now, if you leave your business to your children in a will, but never create a buy-sell agreement or a succession plan, well, after your death, the business could be stuck in probate and the bank could freeze the accounts and the operations can completely come to a halt. So you really need to make sure that you build a clear continuity plan, ensure the business stays running, and protect its value. Complex family relationships or estranged heirs. All right, so I don't know how old my viewers are, but the Brady Bunch, it becomes pretty evident to people. They come and meet with me, and sometimes they're embarrassed by, oh, I've got, an estranged child. Well, I can tell you that the majority of families are not the Brady Bunch. And if somebody comes to me saying everybody gets along and everything's great, hunky-dory, I have to dig a little bit deeper because there's usually something there. So don't feel awkward, don't feel unusual if there are some issues within your own family that you need to address. So dealing with estranged family members is nothing unusual. But an example that has recently come up is a client of mine has been in a relationship for over 20 years and they were never legally married. And they think, well, you know, this is a relationship everyone understands, that I want to leave everything to this person. They ended up putting beneficiary designations on things, but they never forgot, they forgot about the deed to the house. So because this individual didn't create a legally binding will or a trust, the partner of over 20 years was evicted basically from their home, and the kids got everything. So do-it-yourself documents. You don't often anticipate the conflicts, but an attorney who's experienced is going to be aware of the pitfalls. It's important to have open communications with the attorneys so that the possibilities can be addressed appropriately. So how to do it right in Michigan, the best practices: hire a Michigan-based planning attorney, draft a self-proving will with clear revocation language, appoint suitable fiduciaries, ideally in-state, review your estate plan every 3 to 5 years after major life changes, include powers of attorney, healthcare directives, and guardianship clauses if needed. All right, so these steps that we just talked about, do-it-yourself estate planning is tempting but risky. It's often more costly in the long run. These steps don't just protect your money, they protect your loved ones from confusion, conflict, and chaos. Michigan law has strict requirements. Getting them wrong can void your plan. You don't want to do that. Holographic wills are legal but vulnerable. Avoid it unless it's a true emergency. So I get that. So is it wrong if I handwrite my will? No, you can handwrite your will, but you know, if it is truly an emergency, and this comes up quite frequently, I will go to the hospitals to do a deathbed will, is what we call it. And, you know, you don't ever know what's going to happen. So I'll go with my notepad of paper, and sometimes I'll draft everything out that they need and have them sign it and date it, and have if they can write, the dispositive provisions put in their own handwriting in the event they pass away, from the period of time of me visiting them that first time in the hospital to them actually getting back out to the hospital again to sign a typed version with my staff. So in some situations, holographic wills will be a good fill-in. Now, protect your family and assets by working with a qualified attorney. All right, so estate planning, it's not just a legal task, it's a final gift to the people that you love. Please make sure that a valid, professionally prepared plan, it gives you peace of mind and it protects your legacy. We're gonna open it up for questions. If you can drop them in the chat or unmute yourself if you can do that, we can talk about it. And okay, so here we have, for the first meeting with your estate planning attorney, should you bring a draft of your and your spouse's preliminary wishes, or should you come to the first meeting without any prep to avoid preconceived ideas? Certainly, if you have taken the time to prepare your thoughts, you can certainly share that in advance with the estate planning attorney, or bring it with you so that it can certainly start the conversation in the direction that the conversation needs to go. It's a good question, thank you. What happens if I die without a will in Michigan? Okay, well, if you die without a will in Michigan, so this is something, it's a big misunderstanding that people have. Number one, people think that a last will and testament will direct all the assets that an individual has at the time of their death. And that's not the case, because a will only direct how an asset passes to the beneficiaries if it's not a jointly held account, if the accounts don't have beneficiary designations, and if they're not in trust. So for instance, you leave your last will and testament, he says everything goes to my 3 kids, but in fact, my spouse is beneficiary on all of my accounts, so my spouse is going to take everything, my kids don't get anything. And a will does go to the probate court. A will is basically a letter to the probate judge stating this is what I want to happen to my assets that are not jointly held or not in trust and do not have specific beneficiary designations on them. So if you don't have a will, what happens to your assets? The state of Michigan has an estate plan for you. It's called intestate succession. And intestate succession, it depends on who you are and who your family members are when you pass away. So if you have a spouse, your spouse is going to take a certain percentage, depending if it's a first spouse, second spouse. If you have kids with another person, they're going to get different percentages. But basically, it's if you pass away with first marriage and children, it's going to go to your spouse and to your children. If you don't have a spouse and children, it's going to go up the family tree to parents and then out to siblings. Any other questions? Okay, can you use an out-of-state lawyer on online services for a Michigan estate? Every attorney has to be licensed in the state in which they're practicing. So if something is going to be taking place in Florida, I personally am not licensed in Florida, so I can't practice in Florida. We do have Florida attorneys that we work with that can prepare specific documents in the state of Florida, such as powers of attorney and a deed. Okay. Do I need an estate plan if I don't have much money? Yes. Everyone age 18 and over at least needs general durable powers of attorney, healthcare powers of attorney, and then anything beyond that. A will is a good backup plan. But yeah, everyone needs at least a minimal of a last will and testament, healthcare powers of attorney, and a will. Okay. Well, I don't see any other questions. So thank you again for spending time with me today. And if you remember nothing else from this first series that we have, your takeaway is, trying to save a few $100s now can cost you and your family thousands and years of stress later. Estate planning is one of the most important things you can do to protect the people that you love. And it's not just about the documents, it's about clarity, confidence, and compassion. And if you'd like to schedule a free consultation, please let us know. And we'd be happy to help you create the plan that works for you. And we hope you tune in for our next webinar, part 2. It is, has the banker drafted your plan? It is going to be on Tuesday, July 8th from 12 to 12:45. Look for the registration link in your inbox. Thanks, everyone.